I've quoted that in terms of the document I'm reading, not that I have drafted the
Okay,
document.
that may not be
Yes.
relevant for a decision
Yes,
on
that's all right.
whether there is
No, that's
application of mind or not.
Now, this is very serious. The
Yes.
cabinet finds it to be selective Article 14 discriminatory arbitrary treatment by the governor. See that, para 13.3. That's a separate point by me. Just read this very, very important one.
Yes.
The selective treatment of Abraham's petition, same day, given
Yes.
the governor's inaction and numerous other pending petitions, such as proposal for prior approval under 17A. Against Namma, every detail is given. Shashikala Jolie, dated 2021. Supersonic speed, same day versus 2021, 3 years ago. 3 years ago. The proposal dated 26th February 24, Murugesharani. That is 6 months ago. Janardhan Reddy. These facts strongly suggest that extraneous factors influence the governor's decision. The Supreme Court has emphasized that actions based on extraneous, etc., Bombay political vendetta. And then, the final advice is at 420. I would say, whether it's appropriate to one side or the other, the page number is appropriate. Now, this page number is also gone in the new sign.
No, that's what I was telling.
Now, the page number is gone in the new sign.
The biggest change in, they said, no, there is no change. The biggest change is 420 is gone.
It's a psychological
Cheating
change.
is gone in BNS.
But when I say 420 was never a section. 420 was a metaphor, always.
Yes, that metaphor is no longer in existence.
You remember the very old Bollywood film in black and white?
Yes, Sri 420. That is also gone.
So it was a metaphor, that metaphor will always remain, whether you have
Metaphor
any
will
sign.
remain.
That's right.
But 420 goes away.
That's right.
Yes.
So now the final order is, the Honorable Governor ought to have, under the present set of facts, acted only on the advice and aid, not in his discretion. While proceeding to issue show cause, failed to consider the material available, ought to have taken into consideration the reply submitted by Chief Secretary on 26/7, received by the Governor at 6:30. Chief Secretary inter alia highlighted the direction, constitution of Judicial Commission, etc. And then, all these reasons are given, and finally said that you are obliged to. As far as I am concerned, I have separately filed a reply. I have not said that, look, I will not file reply because you are acting without jurisdiction, which you are. But without prejudice, I filed a reply, detailed reply. He has not considered that. Some of your lordships can add to the fact, he does not consider the cabinet's note, he does not consider my reply. Obviously, they will overlap in terms of content, in terms of substance. Now, let me come to so this is the one major point, in terms of the proposition. I go to the next one immediately. You, as the governor, are acting in a judicial reviewable capacity in granting or not granting approval, which my lord actually rightly and pithily summarizes as 17A/218. What you say is judicially reviewable on the standard classic grounds of relevant considerations, extraneous considerations, Wednesbury reasonableness, eschewing this thing or that thing, etc. Lordship knows that well. Forget that. My lord doesn't have to do that exercise. My humble and respectful submission is there is nothing. Your lordship read the order. Your lordship will do the exercise of Wednesbury reasonable after you see some reasons. The only sole reason is I am not bound by your advice. Hence, sanction or permission or approval. This is proposition 1 with the 2 judgments. The second is 17A, my lord read in the order. I'll just note 2 or 3 things. Just take 17A. I'll just be very brief once. 17A. I don't have to read any case law, though there are many. The section makes it clear. PC Act 17 capital A, as the lordship knows well, came in 2018. July 2018.
Yes, 26/7.
No police officer shall conduct, and it starts with that.
Yes.
No police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by a public servant. So, alleged to have been committed by a public servant. Where the alleged offence is relatable to any. Now just look at the. Are you not violating the legislative intent patently? Just give me a second. Put a full stop after the word act on the 3rd line.
They limit, they don't put a full stop. They add a suffix. No police officer shall conduct, but additionally, even if he conducts, suppose if it's a non-police officer, the first condition goes, you can't do it. There is no police officer, here is the complaint. Second condition is supra-added.
Not yet.
Yeah, that's right.
Not yet a police officer.
Not yet. That's correct. No, we are talking of now
the 17A stage, which is mentioned in the order. We are talking of that order. What will happen later is different. Now, where the alleged offence is relatable to any recommendation made or decision taken by such public servant in discharge, as my lord noted of his official. Now, where there from 92 to 22, the file never came to me in any capacity. So neither decision nor recommendation. What you are really confusing is with an alleged beneficiary to constitute, sir. So you can't violate the section like that, Malas, on the face of it. You cannot violate the language of the section. Now, Malas, please see. This is still granted. Despite that, there are 3 judgments of Lordship and Note, Malas. Sri Rupa, I believe, which is
All are mine.
judgment, my lord judgment.
All 3 you have cited are mine.
Malas, I always am very hesitant to cite a case authored by the same judge before whom I am arguing. Malas, I appeared many moons ago. I have told this to many people in the Supreme Court, and my learned friend has heard it also.
I saw the index and
But
all
it-
3 judgments are
So
mine.
I am grateful, Malas. Your Lordship knows it well. Lordship will not have the citation. Give it to my learned friend, please. Kindly hand it over to him.
Yes.
I was telling Your Lordship the slight aside, which I have told my learned friend many times in the Supreme Court also. I was arguing a matter before Justice Chinnappa Reddy. And Justice Chinnappa Reddy, Malas, I came across 3 decades ago. I cited a case on all 4s in my favor. And it was authored by him as High Court, Andhra Pradesh judge. So after Malas, he had a very twinkle in his eye and a sense of humor. So after 2 minutes, he says, but Dr. Singh, we did not realize that I was waiting for a chance to overrule myself. So Malas, I am sure Your Lordship is not waiting for that chance. Each of these 3 judgments, may I save time, it's not to be brushed aside. Malas.
It's an application of mind.
No, Your Lordship has given reasons.
Yes, I have reasons.
It can't be just ignored, Malas. I mean, I can understand there's a contrary division bench of Karnataka, there's a contrary Supreme Court. How can there be a contrary Supreme Court of what Your Lordship has written, Malas? With great
I
respect.
don't know if Supreme Court has written.
No,
something
on
else.
this point, there can't be, Malas. What is Your Lordship said? My Lord has said that on 17A, the conditions precedent of the sections have to be, the mind has to be applied. Mind will be applied to what, Malas? To the condition precedent of the section, obviously. So this is not something which, Malas, it can be overruled. Your Lordship has applied the law. And all 3 judgments, Lordship remember, Sri Rupa, Dr. Ashok V, and Praveen Kumar.
Yes.
3 judgments. Your Lordship has got the para, may I? Malas?
First one was Praveen Kumar.
Yes.
Gulbarga-
Praveen is
Gulbarga.
14 to 16 para numbers, and Malas, the others are 23 to 28 is
Yes.
that Sri Rupa. But my lord knows this. So you give the pages to him on the compilation. Otherwise, I don't want
It's
to
here, sir. I'll
repeat
go
it.
through it.
Now, note 2 more things, Malas, on 17. So first point on 17A is conditions precedent of section. Number 2, Your Lordship's judgment. Number 3, there are 2 circulars about criminal law approach and investigation under 17A. One circular is by the High Court of Karnataka. Just
That is after judgment in JV Ashok.
I'm grateful.
Yes.
So one is that, Malas, at 260 of the paper book. Just note that.
Given that.
And there is
circular.
one by the central government, a SOP. 1 second.
Which is the central.
First one is 260. Just for 15 seconds, just pause it that, Malas.
260.
Yes, that is 23rd September 2023.
Volume 2.
Huh? Volume 2.
Petition. Writ petition.
The writ petition, no, not the law, not the law compilation, the main writ petition file.
Page?
No, not the.
No, please. First is 260. I'm on the High Court of Karnataka Circular, 260. I emphasize it is mandatory. Please follow it
No,
strictly.
this is
That's all.
after Dr. Ashok's.
That's right. So I'm just pointing out the circular 260 of the paper book. Now the second one is 703, which is the last page document, which my learned friend was saying, on 3rd September 2021. 703.
Yes.
And the last 3 paras of that are relevant, which are paras 2, 3, and 4 at page 704. So as to standardize and operationalize procedures with a view to achieving uniform and effective implementation for prior approval processes, a set of SOPs are hereby conveyed. The SOPs provide for stage-wise processing of information received by a police officer, specify the rank of police officer to seek prior approval under section 17A. Considering the proposal under 17A by the appropriate government or authority, laying down a single window. Well, the condition because section is not looked at, so where is the question of doing all this? All administrative authorities, including ministries and departments of central and state governments and IAs, investigating agencies, are requested to take note of the SOP as appended herewith, bring to the notice of all concerned, etc., etc. So I've done 3 points. Natural justice is clear. The first point was name of Mr. Abraham. Actual order has 2 more. Those 2 more never supplied to me. The order is based on those 2 also.
Second point is he does not discuss or give any reason. Third point is 17A. Fourth point is Malas 218. And he turned to 218. What is the point here, Malas? At page 47, the learned governor grants Malas an order which invokes 218 of the Sanhita. At page 47.
Yes, I am there.
Right, Malas? Now, Lordship knows in pari materia 2197 and all that. Now, the language of 218 itself makes it clear that it has to be offense specific, ingredient specific.
Yes.
Resistance to taking of property by lawful authority of a public servant. Whoever offers any resistance to taking of any property by the lawful authority of any public servant, knowing or having reason to believe that he is such public servant. So knowledge is important, Malas, mens rea. Such shall be punished with either description. But suppose I go to somebody and say, you're guilty of 218, you're guilty of 218. 218 is not an end in itself, Malas. You have to show what 218, what ingredient, what offense, how. How is important. See page 47. Lordship find nothing. Page 47 is nothing. It says exactly what I am saying. 218.
There may be other points I'm not arguing now, Malas, on that point that 218 came now. This offense relates to Malas when.
No, since
But that's all right. I'm not, your Lordship will have to see whether it applies back or
it's
not.
taught after BNSS and being granted, it is only BNSS.
I am not even arguing that for the time being.
Yes,
I don't
that's
want to get into that. Now, there's two more things that I'm done. One is, Malas, the larger issue of selectivity of these four other complaints, which my lord has noted that one page of the cabinet
That I
decision.
have seen. Let them all file their
Names are given.
objections.
Names are given there, details
No.
are given.
Let the respondents file their objections if they want to.
That's right. If they say that, look, for this reason, I could not decide a 2021 complaint, but I decided yours on the
So
same day.
let the, even the,
So, Malas, I am saying,
SG is learned SG is representing the
My
governor.
instructions are, there are no sanctions pending.
let me end,
Yes.
let me just end. Please allow me to finish. Malas, one thing which is larger issue, not today, but Lordship should know the flavor of it. Just turn to 155 para number of Nabam Rebia. I'll be very brief because
155.
para number. Now, I hope we get it correct this time.
Page
869.
Turning it and saying it.
para 155.
Now, 155, that your lordship's 1027.